Ladies and gentlemen, today, after discussion on various aspects of constitutional rights, today we are going to discuss the right to constitutional remedies, which is guaranteed under Article 32 of the Constitution of India. To start with, Part 3 of the Constitution of India declares fundamental rights to act as a curb on the tyranny of the executive as well as the legislature. But mere declaration of fundamental right is worth nothing unless there is machinery for enforcement. Article 32 of the Constitution is described as a constitutional remedy for enforcement of fundamental right in Part 3, and the right to bring such proceedings before the Supreme Court of India is itself made a fundamental right. If rights are conferred, then some remedies must also be provided so that such remedy may be used to maintain a right in case of violation. This is expressed in the Latin maxim ubi jus, ibi remedium, that is, there is no right without a remedy. In the Constitutional Assembly, Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constitution, said, "If I was asked to name any particular article of the Constitution as the most important article without which this Constitution would be a nullity, I would not refer to any other article except this one, Article 32. It is the very soul of the Constitution and the very heart of it." The jurisdiction given to the Supreme Court is very wide, but limited to the enforcement of fundamental rights. And for that purpose, it can issue not only writs analogous to English writs, but also any direction or order in the nature of the writs. And the Supreme Court may improve upon them and may come over the technical deficiencies, if any, to mold them to Indian conditions. In Chirajit Lal versus Union of India, 1950 Supreme Court Journal, page number 869, the case came up before the Supreme Court of India, wherein the court took the opportunity to define the scope of Article 32. It has been defined, Article 32 gives very wide discretion in the matter of framing our writs to suit the exigencies of particular cases, and the application of the petitioner cannot be thrown out simply on the ground that the proper writ has not been prayed for. A sound knowledge of the fundamental rights enshrined in the Constitution and the remedies for enforcement is imperative for the sake of the learners as well as the lawyers of today. It requires analysis by detailed study that the Supreme Court power under Article 32 is the power to issue appropriate directions, orders or writs for the purpose of enforcement of fundamental rights. A writ is a formal order in writing issued in the name of the sovereign, court or an authority commanding a person to do or refrain from doing some act specified therein. The authority or the court is to exercise the power in the interest of justice. The Constitution framers were aware of the part played by the writs in England and consequently made specific provisions in the Constitution empowering the Supreme Court and the High Courts to issue writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for enforcement of fundamental rights, and giving additional power to the High Courts to issue such writs for other purposes under Article 226. So far as enforcement of the fundamental rights are concerned, the jurisdiction of the High Courts are substantially the same as that of the Supreme Court. Therefore, the nature of the different writs requires to be appreciated. The term habeas corpus is a Latin phrase, means have the body. This writ is in the nature of an order calling upon the person who has detained or arrested another to produce the letter before the court in order to let the court know as to on what ground he has been confined. And if the court does not find any legal justification for detention, it shall set him free. The value of the habeas corpus is that it enables the immediate determination of the right of the detainees, their freedoms. A writ of habeas corpus may be issued against any person or authority who has illegally detained or arrested the person. Since the aggrieved person is under detention and personally unable to make the application for the writ may be made by any other person having interest in the prisoner. Mandamus means command. The nature of the writ is that it will demand some activity on the part of the body or person to whom it is addressed. The applicant must have a legal right to the performance of legal duty of a public nature, and the party against whom the writ is fought is bound to perform the duty. In the matter of enforcement of fundamental rights, it is the duty of the Supreme Court and the High Courts to enforce the fundamental right by issuing the writ whenever a public officer or a government has done some act which violates the fundamental right of a person. The court would issue a writ of mandamus restraining the public officer or the government from enforcing the order or doing their act against the person whose fundamental right has been infringed. The conditions necessary for claiming a writ of mandamus are that the applicant must have a legal right. No one can ask for mandamus without a legal right. The another requirement of a writ of mandamus is that the opposite party must have a legal duty to be performed. There must be in the applicant a right to compel the performance of some duty cast on the opponent. A writ of certiorari or prohibition is issued practically on the same grounds. The only difference between the two is that certiorari is issued when the proceedings have closed in a lower tribunal and decision has been given, while prohibition is issued when the proceedings have not been completed. The idea behind is that prevention is better than cure, For example, the court can issue prohibition if the authority started acting under an unconstitutional statute. But if the tribunal has given the decision, then certiorari is the proper remedy. The writ of certiorari or prohibition is issued on the grounds like if the body is quasi-judicial but acts under an invalid law, or for correcting errors of jurisdiction when it acted without jurisdiction, or it acted in excess of it, or fails to exercise a jurisdiction vested in it. Quo warranto means, what is your authority? It is a judicial remedy against an usurper of a public office, franchise or liberty. The nature of this writ is that the usurper is called upon to show to the court as to by what authority he holds the office, franchise or liberty. If the holder has no authority to hold the office, he can be ousted from the employment. A quo warranto lies against a person who has said to be usurped a public office. The state is not a party in a proceeding of quo warranto. The usurper is the only party who is to show the validity of the appointment, and the state does not come to the picture. The law of compensation has been civil law remedy. Under the law of tort, the victim can claim compensation for the injury to the person or property suffered by them. But one drawback in civil proceedings is that it takes decades to get the relief of compensation. The question is why the High Courts or the Supreme Court, in exercise of the power to issue writs for the enforcement of fundamental rights, to forge new tools and devise new remedies for the purpose of vindicating the precious fundamental right to life and personal liberty, it would be proper to refer to the Article 9, Clause 5 of the International Covenant on Civil and Political Rights, 1966, which states, anyone who has been the victim of unlawful arrest or detention shall have an enforceable right to compensation. The content of this article is that every victim will have an enforceable right to compensation. Article 32 confers power on the Supreme Court, and Article 226 confers power on the High Courts to issue direction, order or writs for the enforcement of fundamental right. A question came up as to whether the courts in exercise of writ proceedings can award compensation to the victims. The Supreme Court of India answered in affirmative in Rudul Shah versus State of Bihar, reported in AIR 1983, Supreme Court, page number 1086. The verdict of the court in this case brought about a revolutionary breakthrough in the human rights jurisprudence by granting monetary compensation to the unfortunate victim of the state lawlessness on the part of the Bihar government for keeping the victim in illegal detention for over 14 years after his acquittal of a murder charge. In Ahibam Ongbi Lehau Devi versus State of Manipur, AIR 1999, Guwahati 1, a taxi driver while returning after the taxi service in the night time has been fired upon by security personnel in Imphal West district in Manipur. The Guwahati High Court has granted compensation of Rs 1,25,000 to the widow for depriving the life of her husband without due process of law. Article 32 Clause 4 has laid down that the right guaranteed by that article shall not be suspended except as otherwise provided for by the Constitution. Under Article 358 of the Constitution, while a proclamation of emergency is in operation, Article 19, that is the 6 freedoms, is automatically suspended. The remedy under Article 32 to avail of constitutional remedy is automatically unavailable during the emergency. Further, Article 359 of the Constitution empowers the President of India to suspend the right to move any court for enforcement of such of the fundamental rights conferred by Part 3 as may be mentioned in the Presidential Order. After the coming into force of the 44th Amendment Act 1978, the rights conferred by Article 20 and 21 of the Constitution cannot be suspended during the emergency by the Presidential Order. Therefore, even during emergency, a writ of habeas corpus for enforcement of the fundamental rights guaranteed under Article 20 and 21 is maintainable. And I want to conclude by mentioning that Articles 32 and 226, which are considered the heart and soul of the Constitution, has been held by the Supreme Court to be the basic feature of the Constitution and not amendable. The idea of non-amendability of the basic feature of the Constitution was first held by the Supreme Court in Kesavananda Bharati versus State of Kerala in the year 1973. Thereafter, applying the concept of basic structure of the Constitution in Indira Nehru Gandhi versus Raj Narayan, AIR 1975, Supreme Court 2299, and in Kihota Holohan versus Jachiliu, AIR 1993, Supreme Court 412, the court settled the judicial review under Article 32 and 226 to be basic structure of the Constitution and hence cannot be amended. So far as the enforcement of fundamental rights is concerned, the jurisdiction of the Supreme Court is substantially the same as that of the High Court. Therefore, even if the right to constitutional remedy is enacted in Article 32 in the case of violation of the fundamental rights, the High Courts are also equally under a duty to protect the fundamental right. In this sense, right to constitutional remedy will embrace the power of the High Courts to issue writs also. So friends, we conclude. Have a good day.